Yes, we have actually thought about the right order, and I think my second thoughts are better. That's to say, we would like to hear you now, Mr. Southey, on why, as I understand to be your position, you don't need permission, and we're against you on that. Why you think you should have it?
My Lord, certainly. Before I do that, just to update you, my learned junior was very diligent and produced a number of relevant statutory provisions. Unfortunately, his chambers misread his email and so only produced one copy of this. So somebody is meant to be running down with additional copies.
That's fine. We're not desperate to have them this minute, yes. But thank you.
I should say the industrial court, interestingly, was a superior court of record.
Yes.
From 71?
Yes, I think so.
That doesn't really surprise me, given that it's I don't mean there's any offensive sense, but given its pretensions, I think it was intended to be a very serious fraud. Yeah.
Dealing then with Article 14, the reason why we submit Article 14 has permission rather, is because the original grounds of appeal, which are in Court Bundle 14, so Court Bundle, sorry, page 13, identifies three issues, the first of which is effectively whether SIAC has the power to award costs to a successful party. That is, we submit obviously a wide-ranging issue, and because of the way we put our Article 14 argument, which is that Article 14 applies here because it hasn't been expressly excluded, on the face of it,
Article 14 applies because
that's a slip of the tongue, I think.
Sorry.
You said Article 14 applies here because it hasn't been expressly excluded.
Well, sorry. What I mean by that is that was sort of oversimplifying things in probably trying to get things on slightly quicker than I should have done. What I mean by that is that if there is a right under Section 14, Article 14 to costs, this isn't a situation where Section 6 applies. Section 6 of the Human Rights Act applies. In other words, if there were to be another way of putting it, sorry, I'm obviously not expressing myself terribly well.
You're relying on Article 14. Well, you're saying because there's no, it wouldn't be contrary to any primary.
When looking at the scope of the inherent powers, if Article 14 would be violated without the power to award costs, then Article 14 produces the same result as we're arguing for as a matter of domestic law.
And who'd be violating Article 14? Who's the public authority for the purposes of Section 6?
Well, the public authority would effectively be SIAC on the basis it wasn't exercising its powers in a way consistent with Article 14, because it wasn't awarding costs when it should do in light of the first-tier tribunal's powers. And that, just to put that in context...
So the comparative for this purpose is somebody who's litigating in the FTT?
Yes, exactly. The skeleton, the last iteration of the skeleton before the...
Sorry, before you leave the grounds of appeal, can I just ask you this? I mean, what 52C, paragraph 5, the grounds of appeal must identify as concisely as possible, and no one could argue that page 13 was other than concise. The respects in which the judgment of the court below is wrong, and you don't say it's wrong because they've ignored Article 14, and that provision is your problem on the grounds of appeal, is it?
Well, my Lord,
You don't need to develop it, and indeed, if you did develop it, you would rightly be told off because. But you haven't even referred to Article 14.
Well,
so how is one meant to know that it's wrong because of Article 14?
Well, my lord, the difficulty, as someone who drafts grounds of appeal with that provision, because it does talk about as concisely as possible, is that my understanding has always been that what you're meant to do is sort of almost put bullet points as to the points you're relying on, and we're saying there is a power. And what we then go on to develop in our skeleton argument, and this is why I was going to go to the skeleton argument that results in the grant of permission, is that we identify the basis upon which we say that power exists.
Well, let's just come back to the skeleton argument in a minute, but on the whole, I'm a great advocate of short grounds of appeal on record in judgments in saying so, but they do need to identify the bullet points. You can't seriously say that if the construction were, as the Secretary of State contends for, the result would be contrary to the Article 14 of the Convention, was not a bullet point that needed to be pleaded.
Well, Lord, I obviously do say that, and I say that simply because, in one sense, the way of testing that out might be to look at the other. The other arguments that I've developed this morning, which nobody is suggesting we don't have permission to deal with, are developed effectively on the basis that the bullet point, which is simply saying there is a legal power, is sufficient, combined with the skeleton argument.
Okay, I see how you put it.
And the skeleton,
take us to the skeleton argument.
Skeleton argument, just for reference, and I accept this is fairly brief as well, but paragraph 34. Remember, this was a permission skeleton argument, which is why it's been, in one sense, been developed further. Paragraph 34 noted essentially that one.
So sorry, yeah. This is.
Sorry, page 53. Sorry.
There are two skeleton arguments.
This is the.
Aren't there?
This is the. I've deliberately gone to this one because this is the one that was filed for the permission hearing that didn't take place. So this is the one that was before the court finally, effectively, as I understand it, when the court granted permission. And paragraph 34 makes the point that it is surprising that, well, it is striking, perhaps is a better way of putting it, striking there's no power to award costs when costs can be awarded in the first tier tribunal. Then goes on to refer to a Northern Irish case to distinguish it on the basis that the reason why Article 4, the Northern Irish case is one that deals with an apparent difference in treatment of people who are subject to a closed procedure, which resulted in a finding.
Yeah, well, we see what you say. Yeah.
Yeah.
Hardly looks like a separate ground.
Well, but my lord, in one sense, this is the point I'm making. In one sense, it's not. In the sense that we're not. If we were, for example, seeking a declaration of incompatibility,
yeah,
I can see much more force in the criticisms that potentially are made of our drafting, which is because, in one sense, that would be a separate challenge. What we'll ultimately be looking for would be relief in relation to a piece of legislation. Here, what we're fundamentally saying is SIAC is wrong to say it has no power to award costs. One of the reasons for why that is wrong is because without it, you have this distinction, effectively, between litigants in the first tier tribunal and litigants in SIAC. One group can claim costs, one can't, and that breaches Article 14. So,
was this an argument made below?
No, because below,
Did you ask for permission to raise this as a new ground of appeal when you haven't raised it below? Because forget all the kerfuffling about grounds of appeal, perhaps. The point is, if one's looking at Article 14 and justification, one of the questions which you very fairly identify the court needs to grapple with, if there is any impermissible distinction on the face of it, is justification. I mean, what chance have we got of doing justice to an argument like that?
Well, I'm just trying to remember, because I can't remember the exact way in which the submissions were phrased, but clearly one of the issues that, well, first point I'd make is whether or not that is an answer to the points being raised may depend on the point I already made about the grounds, which is that I mean, ultimately, because SIAC concluded that there was no power to award costs, in our submission, that ruling it means that in SIAC's outcome, in the outcome effectively delivered by SIAC, this issue arises. It's not as though it's a freestanding issue. The second point, in any which links in with that that I'd make is that I mean, ultimately, this is, and this in one sense is perhaps a distinction between the point that I made about remittal and the point I'm now raising, is that we would submit that this is ultimately a question of law. Yes, there are issues of justification, but the justification is either going to be in the form of material that is clear on its face, such as statutory provisions which show why the material is, why the distinction is justified, or potentially material from it's likely to be clear on its face, and on the face of it, there is no obvious reason why the approach to the first the approach is different to that in the first tier tribunal.
Well, the Secretary of State or the Lord Chancellor would have to suggest what reasons there might be.
But surely the point, Mr. Southey, is that you and the Secretary of State exchanged written submissions before SIAC made the written decision on costs, and you replied to the Secretary of State submission. So you knew at that stage what position the Secretary of State was taking, i.e. there was no power to award costs. And that was the time, perhaps in your reply, to raise the Article 14 argument, and you didn't.
Well, I accept we didn't raise the Article 14 argument.
I'm struggling to understand the distinction between raising it now and raising it in front of SIAC.
Well, I'm not suggesting that with the benefit of hindsight, I shouldn't have raised it. We should have raised it. That's not my point. My point is that we're not now prohibited in our submission from raising it, having reviewed the case inevitably, and
because it's a pure question of law. Is that your argument?
No, because the primary point we're making is that we're entitled to raise it in part because of the fact that ultimately the question is, does SIAC have the power that we say it has? And in relation to that, it's obviously important the court resolves all arguments in relation to it. It would be somewhat unsatisfactory in our submission if the court were to say, well, as a matter of domestic law, we don't think there's an issue here, but we'll leave it to the next SIAC appellant to raise the Article 14 issue.
Well, that might or might not be a powerful argument if we were in a position to deal with it, if it was a pure point of law. But you slightly backed off. At one point, I think you did say you thought it was a pure point of law, though you didn't when my lady asked you just now, and I can see why, because justification is not a pure point of law in that sense.
But the issue of justification is one. Well, the issue of justification is, I mean, Lord Reid made the point in, I think it's SC relatively recently, that when looking at justification of a piece of legislation, in this case we're looking at the absence of a piece of legislation potentially, the primary sources, the primary material one needs to look at is what the legislation says itself, effectively, whether the legislation, whether the legislative scheme draws a basis.
Well, I'm not sure that's right. Actually, what you're saying would be contrary to Article 14 would be the decision of the Lord Chancellor not to make provision for costs, having been empowered to do so. Or, you might say, his omission to make a decision, but it's the same point.
Well, but my lord, well, in one sense, that may depend on that may depend on how one resolves the primary issues, obviously, because in the sense that if
you've won the primary issue, you don't need Article 14. If you do need Article 14, it's because you've lost the primary issue. It's
because I've lost the primary issue, but that doesn't necessarily mean. I mean, there is a subsidiary issue which isn't necessarily tied, doesn't necessarily go sort of in tandem with winning or losing, and the subsidiary issue is the meaning of subsection 2A, I think it is, of Section 5, the provision, the rule-making power, because obviously our submission is that because of the terms of the 2007 Act, is not a provision that would enable a power that doesn't otherwise exist to be granted. Our provision, as our position is, as I argued it this morning, that.
So what you seem to be saying, or conceding, or accepting, is that the Article 14 argument is not in any way straightforward, because who is the public authority for the purposes of Section 6 may depend on the precise nuances of the argument. So it might be SIAC, or it might be the Lord Chancellor.
I don't know. I don't. In terms of who the public authority is, I don't back down from the position that SIAC is the public authority quite clearly. It's a bit like, I mean, if one thinks about how one structures a challenge to primary legislation, one structures the challenge to primary legislation by challenging a decision, even if you know it is inevitable, taken by a public authority under a piece of legislation. You don't challenge because Section 6 makes it clear that the challenge isn't an unlawful act under the Human Rights Act, is not the making of legislation. So, to use an example, in prisoner voting, you challenge the decision of the registration officer not to.
Yes, I see that.
Yeah.
But nevertheless, when looking at justification, you have to look at it from the point of view of the person who made the rule, which the person who breached your rights has followed, or interfered with your rights has followed. So we would have in practice, and this may not be the end of the world if we were in a position to do it, to know the thinking of the Lord Chancellor. In a certain sort of case, the government asked to intervene for that very purpose. Here it probably wouldn't be necessary because they'd feed it in through the existing defendants. But the fact is that exercise hasn't been done at all.
Well, the existing defendant has made some submissions, certainly as to what the justification is in her skeleton argument. I think we having gone through it again, we believe that there are two justifications identified. Effectively.
Thank you. Sorry. Well, Justice Dingemans divined what I was reminding myself of, the index to the white book being as hopeless as it always is. It rules about points not taken below 52.21.11. But I think we know what they are.
Yeah.
most jealously scrutinised, cases Vitalis and Grant, always cautious, won't be done if we necessitate new evidence, or trial might have been conducted differently. Even where the point might be to the pure point of law, the appellate will only allow it to be brought to raise a free criteria for satisfied the other party has had an adequate time to deal with the point, the other party hasn't acted to his detriment, the other party can be adequately protected from costs, and so forth. There's more generalities there, but if you want to look at them, you've probably done that already. Yes. Well, you obviously get the chance to reply when you hear what Ms. Giovanetti says, but is there any more you want to add on?
Well, the only, but given I think sort of where we are, I'm not going to spend a lot of time doing this. So obviously, the other point I would make is that we would submit that the Article 14 case argument is well, both a strong one and potentially an important one, because it goes to potentially support the arguments about inherent powers, because that's how the Article 14 compliance would be achieved in our submission. But I am conscious that to properly develop the merits,
well, exactly. I think important you might persuade us of summarily. Whether it's strong or not, you'd have to argue it to see whether we thought it was strong, so it doesn't really get you anywhere.
No, but it's in one sense its relevance goes back to the point I made a moment ago, which is that if the court is going to authoritatively determine essentially whether or not SIAC has a power to award costs, it is perhaps undesirable for it to do that without considering all the issues that point to that power to award costs. And in one sense, that's why the issue has risen as it has.
Yes, thank you. Anything else?
I think that probably covers everything I can say at this stage.
Yes, Ms. Giovanetti.
Lords, my lady. It wasn't clear to us whether ultimately the appellant's position was that all courts and tribunals have an inherent or intrinsic or incidental or implied, because a lot of different terms are used for this, power to award costs, or whether it was the...
So, sorry, you are addressing on the Article 14 point.
Oh, I'm so sorry. Did you want me just to address on the Article
Yes.
14 point now? So, we said it wasn't clearly raised in the grounds of appeal. It wasn't raised certainly below. It wasn't raised, Article 14 wasn't even mentioned in the grounds of appeal to this court. I don't think it was even mentioned in passing in the original commission skeleton, but I'm sure Mr. Southey will tell me if I'm wrong.
I think it was actually.
It may have been.
In,
The original permission skeleton.
There were two
yes.
permission skeletons.
Was it mentioned in the same terms in the two?
I think broadly
The second one comes
similar
in on the
from
back of Ryan.
recollection.
Okay, well, so it is mentioned. It is mentioned briefly in both skeletons.
If that's a bad point, I'm sorry. I looked through very quickly when I saw Mr. Southey was going for the second skeleton.
Yeah, my
but
initial.
I'm sure my lady's right. It may have been
I
mentioned
had
in
a
both.
feeling it was. Yes, it's paragraph 32 of the.
I was looking
original
at 34,
skeleton.
and that's probably where I went wrong.
Yeah, it's similar, and the paragraph finishes with that suggests Article 14 is violated with no jurisdiction.
And it's mentioned in the briefest terms in the permission skeletons, both of them.
Yes, and I wasn't there, but my lady was. I'm not sure actually that Mr. Southey covered this, but Was it mentioned as part of the oral submissions?
Well, there
Well,
weren't
there
in the
weren't
event
any.
any.
Of course, there weren't in the end.
Yeah.
That's right.
And I hope it's fair to say the court would be enormously assisted in considering Article 14 if the arguments had been fully developed. Firstly, before the judge, but secondly, even before this court. And while the arguments fleshed out a bit in the skeleton for this substantive hearing, it is still, in very brief terms, when we all know how complex and difficult issues raised under Article 14 are, and can be anyway. So, for example, in terms of this being within the ambit of Article 6, all we've had to respond to is the submission that there's an obvious connection with Article 6. There's a vast amount of case law in the area, and none of it is fleshed out or developed.
The same can be said of your skeleton, but you would say
Well, we're responding to
you're responding in like style. I mean, it's very
precisely. I mean, it's difficult to respond to.
No, this
the
isn't a
submission where there's
criticism, but it's
obvious
an
connection with
objective
Article
fact.
6. One ends up trying to prove a negative. Only one case cited on Article 8.
yeah.
And justification is obviously an issue on which the courts very often are assisted by evidence. As I understand the way the case is put, it's not that the breach of Article 14 is on the part of the Lord Chancellor by not making rules. So the argument's essentially, parasitic's probably the wrong word, but dependent on the argument that SIAC does have a power and is required to exercise that power in order to avoid a breach of Article 14 taken with either Article 6 or 8. The comparator that's advanced is the first tier tribunal. And in a way, this is rather circular, because as you'll recall, Mr. Justice Chamberlain explicitly went on to consider in the alternative the test that would be being applied if this was a first tier tribunal case, and held that he would not award costs in that event. So, insofar as Article 14, taken with either 6 or 8, requires the court to consider the position analogously to appellants who are running an identical deprivation of citizenship appeal before the first tier and upper tribunals. Even without the benefit of a submission that Article 14 required it, the judge considered that in the alternative.
Yeah.
I think those are really our points on Article 14.
Yes, Mr. Southey, any reply?
Yes, certainly. In terms of the first point about our skeleton being skeletal, if one looks at the Article 14 arguments, in circumstances obviously where we are restricted, what we seek to do obviously is produce a skeleton argument with conscious of the fact that the Court of Appeal procedure rules, among other things, make it clear we need to be concise. We expanded our arguments over 2 pages. The paragraph that is particularly highlighted is the paragraph about ambit. It is not correct in our submission to simply say, well, we just assert a connection with Article 6. What we seek to do there is, by reference to Clift, which certainly we understand is still the leading authority at Supreme Court level, is give the court the best assistance we can as to the approach to be taken to quite a difficult issue, which there's not a huge amount of guidance about, which is what sort of linkage do you need with a substantive right? Because quite clearly, you don't have to establish a breach of a substantive right. You don't even have to establish that the substantive right is an issue. What you have to do is demonstrate a sufficiently clear link with a core value.
Does Article 6 apply to deprivation of
It doesn't, but that's the point. It's the core value. What is the core value of, and this is why we cited Clift. What is the core value of Article 6? The core value is procedural fairness. So it is effectively costs part of that. And
the more you develop this, Mr. Sally, the more one wonders whether, even if we were to give you permission, we'd be able to deal with it today.
Well, it's that may be an issue time-wise. I accept that may be an issue because of where we are time-wise. I have to say I've been, and I'm not making any complaint about this. Far from it. It's been extremely helpful from my point of view. But this morning's argument took significantly longer than I anticipated, to be frank. In terms of justification, my learned friend makes a point, and I accept this is right, essentially, that the issue here, because of the way in which it's raised, is not so much whether or not the Lord Chancellor should have legislated. It goes to effectively what the scope of the inherent powers are. That's the way in which we anticipated it. And so to that extent, in one sense, the justification comes down to things that can be said on the face of the legislation, I suppose.
Well, I'm not sure about that. As I think I put it to you before, granted you're probably right, the actual target is what effectively is SIAC for not doing something which you would say under Article 14 it was required to do. But that was because on the face of it, a common law, a domestic law, it has no power. And one would have to look into whether there was a reason why it didn't have any power.
Well,
And whether you did that by evidence from someone in the Lord Chancellor's Department, or Ministry of Justice, I should say, or by the Secretary of State, or by anyone else, you would need potentially evidence.
well, except, my Lord, the difficulty, I mean, the way in which I think we looked at this, rightly or wrongly, which in one sense is consistent with how we've sought to articulate it, rightly or wrongly, is that if one considers, for example, the issue of the two different academic approaches to inherent powers, the Dockery and Jacobs approach, one way of looking at those is to say that they both recognise that courts have powers that aren't necessarily derived from statute, that are inherent. But one effectively says this is broad, wide-ranging to do justice. The other says essentially that you only have inherent, or the courts only have inherent powers in relation to specific issues where inherent powers are deemed by the courts to exist. Now, if that second approach were to be adopted, that in one sense raises the issue of what are those circumstances. And Article 14, in one sense, is this is the primary way in which we envisage raising Article 14. Article 14 is an argument which suggests that costs should be one of those circumstances, essentially. Now, that's an area where, picking up on Leonard Friend's point, it's not clear necessarily anyone will have thought about that, to be frank, because it's ultimately a question for the courts as to how they develop. And that's where, in my submission, justification effectively is primarily a matter for the court.
Yes.
My lord. In terms of the issue of whether it assists in any event on the basis, of course, that may depend on, if you like, the submission I made before lunch, which is that ultimately, if the inherent power exists and it hasn't been regulated, and the inherent power exists because otherwise there's a breach of Article 14, you then come down to the issue of how that should be regulated, effectively.
Right, thank you. We'll rise a few minutes.
Are they sorted?
They are separated into each separate
Do you want to give us three complete sets, or four complete sets, give one to Lisa as well? I want you to...
Mr. Southey, we don't propose to allow the point based on Article 14 to be argued, and we will give our reasons when we give our reasons for the our decision in the appeal overall.
Can I just hand up? We do have the provisions I promised.
Oh, thank you.
Sorry.
Right. So we can you can have another run at
Yes.
we had a sentence or two of.
So I think I was saying before I moved on to Article 14 that it wasn't entirely clear to us whether the appellant's final position was that an implicit or intrinsic or inherent power to award costs inures to all courts and tribunals as part of their power to ensure that they can do justice, the way it's put, or whether it's an incident of being a superior court of record, and that when Parliament made SIAC a superior court of record, whether or not it appreciated that's what it was doing, it gave it power to award costs. So I'll start, if I may, with the superior court of record point, because if we're right that a superior court of record doesn't have intrinsic costs powers, it probably follows that inferior courts and tribunals don't have them either. So the first point is that if my learned friend was right that there's a wide inherent power to award costs that all superior courts of record enjoy, Section 51(1), the Senior Courts Act, would be completely unnecessary. And obviously there's a presumption that Parliament doesn't act in vain. His answer to that is...
We just ask, was Section 51 new in 1981?
No, and that's the next point I'm about to go to. It's a linked point, but no, and I can deal with both of those by reference to aid and shipping, if I may. So, yes, he says that it was new, and all it did was define powers that the courts had been exercising just as a matter of practice up until then. He says that by reference to the Osman case. We say that's wrong on both fronts, and we can make that good by reference to aid and shipping. And the bits of aid and shipping that we didn't look at. So firstly, looking at whether the House of Lords held, whether its reasoning is consistent with Section 51 just defining the limits of a power rather than conferring power, should we go back to page 434, that's in tab 13, 0434, and pick it up. It's a sideline section between the two hole punches, just by letter E. This is Lord Gough. It is, I consider, important to remember that Section 51(1) of the Act is concerned with the jurisdiction of the court to make orders as to costs. Furthermore, it's not to be forgotten that the jurisdiction conferred by the subsection, expressed to be subject to rules of court, as was the power conferred by Section 5 of the Act of 1890, and we can get to that in a minute. So we then go to a couple of sentence, a couple of lines dealing with the Rules Committee. Can I then pick it up, just the line above the letter F, beginning with the word jurisdiction, under section 51.1. In these circumstances, it's not surprising to find the jurisdiction conferred under section 51.1, like its predecessors, to be expressed in wide terms. So we're dealing here with, just repeated, this is jurisdiction that's being conferred, not defined or regulated or circumscribed.
Or confirmed.
Or confirmed, precisely. And then just the final sentence of that paragraph, 4 lines up from the end of letter H. It comes therefore as something of a surprise to discover that it has been suggested that any limitation should be held to be implied into the statutory provision which confers the relevant jurisdiction. Now, as to the predecessors, we get that very conveniently on the same page. It's just at the top of the page. It's not sidelined, and I'm sorry, we probably should have sidelined it. I didn't quite anticipate the way the argument was going to develop. The first line, the first complete sentence. Section 51.1 is, for all material purposes, identical to Section 51 of the Supreme Court of Judicature Consolidation Act 1925, which itself is, for all material purposes, identical to Section 5 of the Supreme Court of Judicature Act 1890, an act passed to amend the Supreme Court of Judicature Act 1873 to 1875. So it's a long line of statutes. In fact, Mr. Deakin...
Can I just read on for a second?
Yes, of course. It then goes on to the rules. But...
Yes, so in fact, he goes back to Section 5 of the 1890 Act, because that used those particular words, but even that is not the origin of the... That's not the end of the statutory trail.
No.
Because I'd forgotten this if I ever knew it. The original rules of the Supreme Court were themselves a schedule to the 1873 Act, or 1875 Act. We see the rules of court contain Schedule 1 to the 1875 Act. Order 55 contained those words. The best that could possibly be said, but we just get lost in history, is it's not clear what the position was before 1875.
No. And in fact, we didn't add it to the voluminous authorities you already had. Maybe we should have done. But Mr. Deakin's diligent researchers found an article in the Yale Law Journal which says the first statute which gave the plaintiff his costs and the one on which the whole law on the subject was based until 1875 was the Statute of Gloucester 1275.
which is referred to in the West Union case. But one of the points about page 975 and the history is that talks in terms of High Court.
Yes.
And that's why West Union needed to be decided, because they had said nothing about the House of Lords.
No.
So you can't sort of just say it's all statutory, because it wasn't.
No. Certainly the House of Lords wasn't. I was going to move on to that.
Yeah.
But in terms of the High Court, which of course is a court of unlimited jurisdiction as well as being a superior court of record, the cost power has long been conferred by statute. Very long.
And that's when you do go back to 1291.
Yes.
Yeah.
So can we then turn to Osman, which is a case which is a little bit on its own. It's Mr. Southey's second authority
Sorry
about
to interrupt, could we maybe be sent the
Yale
please?
article.
That sounds
Yes.
rather interesting. Thank you, Mr. Deacon, for finding it.
So, yes, so the second example which Merlin gives of the court's holding that there is an inherent jurisdiction to award costs. The first is the West Ham case, which we'll come to in a moment. That is Osman. And Osman is a very unusual case because it's not dealing with superior courts of record generally. It's dealing with very, very specific proceedings. It's dealing with the Divisionals Court, habeas jurisdiction, in a criminal cause or matter. And the analysis starts at page 443, looking at section 51.1 of the Supreme Court Act.
I'm so sorry, could you remind me which tab it is?
Oh, I'm so sorry, my lady. It's tab 14.
No, I think I'm being slow, thank you.
is a really
It's the very
short
next
judgment.
tab.
On page
Thank you.
453, did you say?
No, sorry, 442, the report
Thank you.
starts.
Thank you.
And the sort of analysis of where the power comes from starts just below the bottom hole punch from 443. The jurisdiction to award costs in the present case, if you have that. Jurisdiction to award costs in the present case derives from section 51(1) of the Supreme Court Act 1981, which provides, and then it's read out. And then reference to a note, page 937 of the White Book under the heading habeas. And then the court continues, on any view, the proceedings in the divisional court was proceeding from the High Court within the meaning of section 51(1) of the Supreme Court Act. If therefore section 51(1) had stood alone, Mr. Ross Monroe accepts it would confer jurisdiction to award costs in this case, but he submits that 51(1) is cut down by section 51(2). That subsection provides, nothing in subsection 1 shall alter the practice in any criminal cause or matter or in bankruptcy. So the court then goes on to consider, is this a criminal cause or matter? And finds that it was. So at the end of the citation from Hammond and Home Secretary, Lord Justice Lloyd says, so it's clear that these proceedings were proceedings in a criminal cause or matter. Then comes the question, it's the crucial question in the case, what is the practice in habeas corpus with regards to costs? It's not the High Court generally, or rather what was the practice when the 1981 Act was passed. Court then looks at the Brixton ex parte Singh case, agrees with Mr. Ross Monroe that there was no argument, but it's not concerned with whether there's an actual jurisdiction, it's only concerned with the practice. Overleaf, first the case of Denmark and Nielsen, not identifying the jurisdiction but simply making the point that the application for habeas corpus was dismissed with costs. And it's against that background that we turn to the sideline bit on the facing page. Where Mr. Ross Monroe submits that the practice in question is corrupt since there never was any power to order payment of costs in these cases. And the court says that's beside the point because the Act directs us to look at the practice, not the jurisdiction. So really, that doesn't demonstrate jurisdiction, it simply demonstrates practice in a very narrow band of cases.
Did they have a statutory jurisdiction to award costs?
I don't think they did. I haven't found one, but certainly...
And if they didn't, does that not suggest that two experienced Lord Chief Justices hadn't just nodded and got it wrong, but were exercising an inherent jurisdiction?
Well, it might suggest that, but plainly the point wasn't argued, so there's no reasoned decision addressing it. And given that we've seen that the High Court generally had a cost jurisdiction conferred by statute, it may be that everybody just assumed that that included habeas corpus, irrespective of whether it was a criminal or civil cause or matter.
But your submission is that those would be decisions wrongly decided then? That they, if they'd have thought about it rather than just assumed, they would have had to say, we don't have jurisdiction because there's no statute.
No, well, I'm not sure I'm prepared to go that far because whilst no statutory jurisdiction is identified in this, nor is there a holding that there was an inherent jurisdiction, and it may well be that if we dig down, I'm happy to do a note on it, we'll do a note on it, but there was in fact a statutory jurisdiction, contrary to the belief of Mr. Ross Monroe, although I'm sure he'd have looked into it with some care.
So his submission was there was no power to award costs, and so the divisional court had erred in what's it, the divisional court? Yeah, so he was suggesting there was no jurisdiction, and there were cases in which such a jurisdiction had been assumed.
Yes.
Yeah. So that's as far as it goes, really.
That's as far as it goes.
Yeah.
But what this isn't is authority for the proposition that there was an inherent jurisdiction. It does nothing more than confirm the fact that it's been assumed. Now, I completely accept that the House of Lords, now the Supreme Court, may be in a different position, and that's the West Ham case at tab 7, which again we've looked at. And that case too harks back to established practice, which is the Lady Justice Laing put to my learned friend in the course of his submissions. What's quite clear is that both Lord Herschel and Lord Macnaghten held that the power to order costs in that case rested on what Lord Herschel described about 10 lines up from the bottom of page 202. I hope I said, sorry, we're in tab 7. What Lord Herschel identified as the inherent authority of this House as the ultimate court of appeal.
They also referred to the Lord Chancellor's practice in Chancery.
They did, but I think they identified that as being a power conferred by statute. That's further up the page.
Well, they talk about 2 centuries of practice.
Yes, they do as well.
Which is and the statute of Richard was common law, not Chancery.
Well, my Lord plainly has a better grasp of legal history and more detail than I do. I think that's right, and I think also the Yale article.
And that was why. And then they said, well, equity trumps common law once you fuse it.
Yes.
Equity had this implied inherent jurisdiction. So it's not just as narrow as saying, which you rightly say, that the House of Lords, that, and indeed they talk about some reservation of grant from the sovereign.
Yes. No, I think that's right, and I think the Yale article says that the Chancery courts approach matters differently to the King's Bench, but that's what none of them say is, as a superior court of record, the High Court has an inherent jurisdiction to award costs. And indeed, it's a bit like the dog that didn't bark. Apart from the equity courts, slightly in a different position, that stems from their equity jurisdiction rather than being a superior court of record. What we don't have is any authority which either party have been able to find, and both parties I know have researched this very thoroughly, to the effect that superior courts of record have an inherent power to award costs. Now, obviously, that doesn't mean that this court is precluded from identifying such power or developing such power. But we'd say that the courts ought to act extremely cautiously before developing the law in that way, particularly in a context where we're dealing with a court or tribunal that's governed by a detailed legislative scheme. And Parliament, SIAC is governed by such a scheme, as we've seen. That's not inconsistent with it being a superior court of record. As Lord Justice Laws made absolutely clear in CART, we've already looked at it, it's tab 23 of the authorities, probably worth turning that up again. So sorry, I had an error in my note. It's not tab 23, it's tab 24, starting at 0647. So the two key paragraphs probably are 75 and 77 on page 676. And 75 is relied on by the learned friend specifically because it reiterates the characteristic of a superior court of record. Picking it up on the fourth line, is that it's presumed to act within its powers unless the contrary is shown. And I'll just deal in passing, if I may, with one of the other submissions that Mr. Southey makes in his skeleton argument. I don't think it was pressed very far, which was the point that, well, unless it has an inherent power to award cost, there'd be no point in making SIAC a superior court of record. It's quite plain from CART itself, and indeed even plainer if one looks at Hansard, that Parliament thought it was immunising SIAC from judicial review. It was plainly mistaken. But Lord Justice Laws identifies here other incidents, which is that SIAC's decisions have effect as precedents for lower tribunals. And so in this particular context, for example, decisions on the law made by SIAC in terms of deprivation of citizenship appeals would have the effect as a precedent for the first tier tribunal, who is determining exactly such an appeal, but which hadn't been certified into SIAC. And then thirdly, the power to punish for contempt. But what's meant about a superior court of record being presumed to act within its powers until the contrary is shown? One has to be quite careful about this, because Mr. Southey elegantly elides that into saying it's got power to do everything that isn't clearly and expressly prohibited. But that's not what Lord Justice Law says, not the language he uses. It's a presumption, it's a starting point that it's acting within its powers. So if one were to challenge SIAC for acting in excessive jurisdiction, you'd have to demonstrate that it was acting in excessive jurisdiction. And how do you do that? By looking at the statutory regime. Because, as Lord Justice Law says very clearly at paragraph 77, the fourth line just after the words say about that, it's talking there about the upper tribunal, he says, nevertheless, like SIAC, it owns only the jurisdiction given to it by statute. And then at pages 678 and 679, he refers to this court's decision in G in the Secretary of State, where Lord Phillips, Master of the Rolls, said, SIAC is a court of very limited jurisdiction. And then what he says at 87, by reference to the upper tribunal, is equally applicable to SIAC, picking it up 5 lines down just by letter H. Though it is not a court of unlimited jurisdiction, being, of course, confined to what TCEA gives it.
So sorry, where were we reading?
Sorry, I'm at 87, my lord, paragraph 87, page 679,
Oh, yes, right, thank you. Yeah.
next to letter H. Though it's not a court of unlimited jurisdiction, this being the upper tribunal, being, of course, confined to what TCEA gives it, its jurisdiction is very wide. And we've seen he's contrasted that previously with the much narrower jurisdiction of SIAC.
Because there he's talking about the upper tribunal as a whole, including
Yes,
all its
yeah,
chambers,
precisely.
not just UTAC.
No, yeah. And indeed, it cannot be that SIAC has jurisdiction to do anything except what's clearly and expressly prohibited by statute, because as Mr. Southey seemed to acknowledge, that was the case. It's not prohibited from making orders about housing. It's not prohibited from awarding damages. The reason it can't do any of those things is because it has only the power that he mentioned housing, I'm mentioning damages, but it's because it has only the statutory jurisdiction conferred on it.
So it's a bit, I mean, maybe this is too crude an analogy. The position of local authorities, as explained in Hazel, and the old cases about what's necessarily implied when you grant a statutory body an express power. But essentially, position for local authorities is if you've got a detailed code governing, say, borrowing, you can't imply a power about borrowing that isn't stated in the code.
No,
it's a similar sort of point.
Yes. You look at how comprehensively Parliament's provided the powers, defined the powers, and that's how you look at the limits of the tribunal's jurisdiction, the Commission's jurisdiction in this particular case. And that takes us back really to sort of the overview in the academic articles by Jacob and Dockeray. And although there are some distinctions between them, those are probably largely explained by the fact that there's a quarter of a century time lapse between them being written. You've got them at the very end of the second bundle of authorities. Tabs 59 and 60. So 1434. Right at the middle of the page, between the two hole punches. So Jack Jacobs says, it's the line beginning with the word jurisdiction. The source of the statutory jurisdiction of the court is, of course, the statute itself, which will define the limits within which such jurisdiction is to be exercised. Whether the source of the inherent jurisdiction of the court is derived from its nature as a court of law. So the limits of such jurisdiction are not easy to define and indeed appear to elude definition. And that's certainly a point on which he and Professor Dockeray are as one. Professor Dockeray says, along a similar vein at page 1463, I won't turn it up right now, but he says, in this area there's little which can be said with complete confidence. The uncertainty of the law is almost the only thing which is never in doubt. But what Sir Jack Jacob goes on to say about the inherent jurisdiction needs to be seen in the context of what he says here in this early part at 1 and 2 at the bottom of page 1434. So, firstly, he makes the point that the inherent jurisdiction is part of the procedural law, both civil and criminal, and not of substantive law. It's invoked in relation to the process of litigation. Secondly, the distinctive and basic feature of the inherent jurisdiction of the court is that it's exercisable by summary process, i.e. without plenary trial conducted in the normal or ordinary way, and generally without waiting for the trial or for the outcome of any pending or other proceeding. Part of the machinery of justice may be invoked not only in relation to the litigant parties, but others. Got to be distinguished from the exercise of judicial discretion. And the powers conferred by rules of court are, generally speaking, additional to and not in substitution of powers arising out of the inherent jurisdiction. And then at the bottom of that page, 1435, he explains how the inherent jurisdiction has developed along two paths: punishment for contempt of court and of its process by regulating the practice, and preventing the abuse of its processes. And he goes on to consider those in a lot more detail. Which at 1442, he identifies three broad groups of powers: control over process, control over persons, and control over powers of inferior courts and tribunals. And it's fairly clear from that and from the references to contempt that he has in mind superior courts of record. And Mr. Southey took you also to the passage at 1461. That the power to make such orders may be necessary for the ends of justice, power to do justice between the parties. But that needs to be read, in my respectful submission, in the light of the preceding paragraph. And I wonder if we could pick that up on the 6th line down, the first full sentence beginning at the end of that line. It stands upon its own foundation, and the basis for its exercise is put on a different and perhaps even wider footing from the jurisdiction in contempt, namely, to prevent oppression or injustice in the process of litigation, and to enable the court to control and regulate its own proceedings. Professor Dockeray, then, at the next tab, writing in 1997, does, as my learned friends say, mention costs, and he does so at page 1464, the second paragraph. He says that the phrase inherent jurisdiction seems to have been regularly used before 1875 only in the law of contempt of court, began to be used regularly in relation to procedural powers, costs and control of solicitors about 1880. This is explored in more detail below. it's not. It's not explored in more detail below. But what we do have over leaf, in case it helps, at 1466. Pick it up in the third line. In the same period, I'm just checking back to see, I think he's talking again about the 1880s from the previous page. In the same period, examples of these words being used to describe other incidental powers begin to multiply.
So sorry, where are you reading from?
I'm so sorry, I'm page 1466, my lord.
Yes, but whereabouts on the page?
Third line down,
Oh, right, thank you.
with the sentence that begins halfway across, through that line, in the same period. And I was just checking back, and I think he is talking about the late 19th century again. In the same period, examples of these words being used to describe other incidental powers begin to multiply. And you see there's footnote 38. And if we turn to the end of the article, footnote 38 cites the West Ham Union case in respect of costs. Well, we've already looked at that and seen what it does and doesn't say about costs.
Also cites Pringle and Secretary of State for India, but that's a chancery case.
Yes. And Pringle's...
Is that referred to in the West Ham Union case?
It is in the argument, where the argument's recorded, and I'll probably get the terminology wrong. It was about proceedings started in error. We go back to tab 7. It's at the foot of page 199. In Pringle and Secretary of State for India, the Justice Laing claims for the court an inherent jurisdiction when it was wrongly put in motion. So I don't know if that would be the sort of the equivalent to the issuing of proceedings which are frivolous, vexatious, don't disclose a cause of action. But that one can see.
It's certainly not generally to do with
it's
costs.
not a general, no.
But the footnote 38 does suggest that the writer of this article has read West Ham Union as not restricted only to the House of Lords.
I'm not sure I'd accept quite that much. I mean, he's covering a really wide field. Of course, this is not an article that's devoted to costs. And he's plainly alighted upon it as a case, which it is, saying that there is an inherent power to order costs. But as we've seen, it says there's an inherent power to order costs deriving from the House of Lords' status as the ultimate court of appeal. Yeah.
Yes, I mean, to be fair, also, all he's talking about at that stage in his development is the terminology being used in different contexts.
Yes. Yeah.
He's not really analysing what its
No,
nature was in any particular context.
No, and he gives quite a wide range of context in footnote 38, as you'll see.
Yes. Yeah.
Apart from that, as far as I'm able to see, Professor Dockeray hasn't identified any case saying superior courts of record have an inherent power to award costs. And as I say, neither of the parties have been able to find one. He gives a list of the inherent powers or jurisdiction integral to the inferior courts or tribunals at the top of 1467. So he says that inherent powers are not exclusive to superior courts. And then he cites the decision in Connolly and the extract from Lord Morris, which we looked at this morning, which is much cited. There can be no doubt the court which is endowed with a particular jurisdiction has powers which are necessary to enable it to act effectively within such jurisdiction. I'd regard them as powers which are inherent in its jurisdiction. A court must enjoy such powers in order to enforce its rules of practice and to suppress any abuses of its process. And he goes on, Professor Docre goes on this view, inherent powers exist because they are necessary if the court in question is to manage the work which has been assigned to it in an appropriate fashion. Obviously, there have been a number of cases citing Connolly, but I wonder if I could just take you to Taylor and Lawrence at tab 17. Pages 504 to 505. And the whole, I suggest, of paragraphs 50 through to 53 need to be read as well as 54, which has been sidelined.
You want us to read through what 50 to? What do you want us to read? That's right.
I think if you read 50,
yep.
Starting point. So as we've explained in our skeleton argument, in Taylor and Lawrence, the Court of Appeal looked at its explicit statutory powers and its functions as an appeal court, and it identified what its inherent powers were by reference to that.
Well, also, it seems that, I forget who's judges the court, isn't it? But there's a distinction between an inherent jurisdiction used in a particular sense. He says in that sense it has no inherent jurisdiction, and distinguishing that from having an implicit jurisdiction.
Yes.
I mean, you could argue forever about whether that's a useful, it's certainly a possible distinction, and one has to be careful in what sense one is using it.
I think both Docre and Jacob say that the language is in some ways a false friend, because people don't necessarily use the terms as being sort of hermetically sealed, and sometimes use one where actually another court or another section
for myself,
of reasoning.
I'd have thought an inherent jurisdiction ultimately exists because it is necessarily implied. You could go on forever like this. So.
No, absolutely. But looking at the underlying principles, those are the powers that aren't expressly conferred, to do what is necessary to achieve the objectives of the court, in that case the dual objectives of an appellate court. And then they cite Lord Diplock and say, Lord Diplock, who perhaps speaks on a subject of this nature, the greatest authority of any judge, has dealt with the inherent power conferred on a court, whether appellate or not, to control its own procedure so as to prevent it being used to achieve injustice. That's what they're talking about when they talk about an implicit or implied or inherent power necessary to do justice. It's not substantive justice, it's not granting remedies, it's preventing the court's procedures being abused so as to achieve injustice. And we see that from the extracts cited from the Bremer case. The High Court's power to dismiss a pending action for want of prosecution is but an instance of a general power to control its own procedure so as to prevent it being used to achieve injustice. Such a power is inherent in its constitutional function as a court of justice. And again, between E and F, it would stultify the constitutional role of the High Court as a court of justice if it were not armed with power to prevent its process being misused in such a way as to diminish its capability of arriving at a just decision of the dispute. And then the court continues at 53. In our judgment, the final words of Lord Diplock, the doing by the court of acts which it needs must have power to do in order to maintain its character as a court of justice, express the situation here under consideration exactly, and then goes on to cite Lord Morris in Connolly and DPP. Of course, I entirely agree that the dividing line between what's procedural and what's substantive may sometimes be a bit of a grey area. Insofar as it's necessary, I say that costs are substantive, they're part of relief. Generally, when they're being awarded at the end of proceedings, of course the court has cost power which are incidental as the proceedings go along, which are part of these inherent powers, but they're powers to control its processes and procedures, to enable it to exercise the substantive jurisdiction it has. So against that background, we haven't actually looked at the decision, I don't think, that's being appealed. You've got it in the core bundle. It's very short, 115 to 118, and I'm sure...
Sorry, can we just, before we leave, Colin, I may have misunderstood your final submission. I thought where you were leading up to was distinguishing between, is saying that the power to award costs is not part of the inherent or implicit jurisdiction of the court, in which is only effectively to prevent it being used to achieve injustice. So things like contempt, things like striking out and so forth, but not ordinary party costs.
No, not ordinary relief at the end of proceedings. It is the point, I was going to make it by reference to what the judge said about whether a cost power was necessary to enable SIAC to do justice.
Yes, I see. Okay, we'll come back to it. I mean,
but I would, and of course, there are all sorts of incidental powers, like how to adjourn briefly, or lots of examples that are given that aren't preventing abuse, but they're just the court regulating how it does its business. Power to award costs at the end of proceedings is very different from those. And so, insofar as I'd be pushed to say whether it's procedural or substantive, there's no difference between it. Some things plainly are substantive, and I'd say that costs they are part of the relief that's prayed at the end of, generally, a pleading, for example.
I was always told you shouldn't plead.
Oh.
Well,
I'm sure
I'll tell you what
right.
I was taught. It just shows how silly all these things are. I was taught that in Chancery, you pleaded costs in your prayer, but common lawyers didn't.
But I always find it at the end of judicial review claim forms, although I'm usually responding to them rather than drafting them myself, but I shall remember that.
Yes, well, purists like me, it's to still turn up our noses at that. But anyway.
So the way the judge analysed it was this. Firstly, at paragraph 12, he said that the effective law justice laws is analysis of the parties, and that the Commission has... I'm so sorry, I don't know if I gave you the page. 117, I'm on the third page in the core bundle.
Yeah.
Third page of his written decision. So the effective law justice laws analysis in CART is not the Commission has power to do whatever it wants unless precluded by statute, but rather that when challenging a decision of the Commission on jurisdictional grounds, a claimant must establish positively that the decision falls outside of its jurisdiction. This really is a burden of proof, or as Mr. Southey quite rightly described, a presumption of starting point. That's irrelevant to the question the Commission must itself answer in deciding whether it has power to do what it's being asked to do. In this case, that turns on whether the power to award costs in appeals under Section 2B is part of the jurisdiction conferred on the Commission by statute. In my judgment, the answer is no. The correct starting point is the text of the statute. That gives the Commission no express power to award costs. B, as a creature of statute, the Commission has no inherent jurisdiction. And that's the bit that Mr. Southey cited, but he didn't carry on because the reasoning continues. There are some situations in which powers can be implied when necessary for the purposes of doing justice. See, for example, Taylor and Lawrence, which we've just been looking at. And then he continues, it's doubtful whether a power to award costs could ever be regarded as necessary for the purpose of doing justice. Many legal systems operate without such powers. In our system, some tribunals have the power to award costs, others do not.
Just pausing there, I was trying to think of tribunals which operate on a basically party and party inter partes basis, where there isn't a power to award costs of any sort. Can you think of any?
The IPT doesn't have power to award costs, and whether or not it has a power to award costs has been argued in front of it a couple of times, and we looked at this over the short adjournment.
Funnily enough, I was going to ask about the IPT. I started looking over lunch and gave up because it looked too complicated.
They've given some examples.
Who are they? Sorry.
Sorry, IPT has. I'm so sorry to be handing up authorities whilst on my feet. If
Don't
I
worry.
could do that. It's very brief. Sorry. The paragraph 6 on the page.
Thank
Is a decision
Thank you.
of Lord Justice Mummery and Mr. Justice Burton. No express power in the statute which created and governs this tribunal.
Sorry, where? Which paragraph?
Sorry, paragraph 6 on the first page, in from the heading. There's no express power in the statute which created and governs this tribunal, RIPA, or under the rules made by the Secretary of State under Section 69 of RIPA to award costs. As this tribunal is a creature of statute, any power must be drawn from the statute. There's no inherent power. As Mr. Allen's pointed out, there are other tribunals which have no express or implied power to order costs. He draws attention to the tribunal procedure, first tier tribunal, health, education and social care chambers, rules.
Yes, I didn't.
Social
Those are the
entitlement.
sorts of ones I had in mind when I was
Yeah.
talking about ordinary party and party. If those
No,
historically, those before the 2007 Act, those were not this sort of tribunal at all.
no. I mean,
Why not?
plainly the High Court and the County Court have statutory powers to award costs. We'll carry on looking, but this is the best we've been able to find so far.
Can I just ask you, whilst you're on that, paragraph 13C, as you pointed out, Mr. Justice Chamberlain said, it's doubtful whether a power to award costs could ever be regarded as necessary for the purpose of doing justice. On what basis, then, was the House of Lords exercising its own inherent jurisdiction to award costs, other than to do justice?
You've been doing it for 200 years.
I suppose insofar as it was said earlier by my Lord Justice Underhill that the overriding objective is something that all courts and tribunals seek to achieve.
Yeah. Maybe we need to put the emphasis on the word necessary.
Yes.
I think most of us would see an obvious sense in which it is just that the winning party should have to be paid for their costs of winning against the party who's resisted it. But clearly what Mr. Justice Chamberlain, in a very abbreviated reasoning, was doing was distinguishing that from the kind of case where you can't even do your job in the substantive proceedings unless you can threaten someone with contempt or strike out an abusive action or step in an action. And I think that's all he probably meant.
I think my Lord's completely right. I'm sorry, I should have paused and thought a bit before jumping in to answer, but yes. not necessary to enable the court to determine the proceedings justly, might be another way of putting it. And despite what Malone and Friend says about sort of creating a one-way sort of cost jurisdiction in SIAC, he's not arguing for a power which would be limited to SIAC, but a far more general power. I think it's probably fair to say that some litigants might be actively deterred from commencing proceedings if they risked what could be a substantial cost exposure. There are all sorts of factors that Parliament, and insofar as the power lies with it, Rules Committee or the Lord Ministry of Justice may take into account when deciding whether or not to confer a power to award costs and in what terms to do so. And there can be a number of considerations. So, for example, Mr. Sadie says, well, you've got closed proceedings, limiting to that context. An appellant should never have a cost order made against him if he loses because of closed material. But if the closed material demonstrates that what the appellant has said in his evidence is clearly a pack of lies, it's hard to see why he should escape an adverse costs order. I mean, it would be complex. And one can see why good reason for not having a power to award costs in those circumstances. Even determining whether parties have acted reasonably is harder when some material is closed and some isn't closed. So I'm not saying it's the only thing that Parliament could have done, but I'm saying it's not patently obvious that in order for it to exercise its statutory powers, SIAC needs a cost power. And plainly, Mr. Justice Chamberlain didn't think it did. I think I've addressed in passing Mr. Southey's submission that designation as a Superior Court of Record would serve no purpose unless intended to confer a cost power. In terms of the rules, we've explained in our skeleton argument how it seems to us that when it was first established, SIAC did have a costs power, or the Lord Chancellor had power to make rules about costs in SIAC under the provisions as they then were. It seems to us at least arguable that there continues to be such a power, although that, for the reasons we've explained in our skeleton argument, though that particular structure has been overtaken by the TCEA. But it seems to us that this court doesn't really need to decide that, because the short point is that no rules have been made. So either there is no power, no enabling provision which enables rules to be made, conferring a cost jurisdiction, or there is an enabling power, but no such rules have been made. In either way, I think the parties are agreed that there is no express provision in the Act or the rules conferring a cost jurisdiction on SIAC, and it's not been suggested that there is one. I think that was all I wanted to say about power before moving on to the position if we're wrong and SIAC does have a power. But I just very briefly turn around and see if there's anything else I need to say. That was very quick. Not just an excellent researcher, but also incredibly efficient. I've got the Yale Law Journal article, if I can hand that round.
Amazing.
That's already been put in hand before we asked for
I
it.
think it must have been.
I emailed my lord and my clerks brought it over.
Gosh, aren't they efficient? Well, please convey our thanks to them.
Thank you.
You're welcome.
Oh,
Thank you very much.
Arthur L. Goodhart.
Wow, May 1929.
We weren't able to find anything in Law Quarterly Review or anything like that in any of the English journals that trace the history back as far back as that.
It's spoken, we see from the first asterisk to a pressure of all souls, so it must be right. Where do we find the reference to the statute of Gloucester?
8852, first main paragraph.
I think it may be overleaf a bit further, but I was interested to read that initially there was the power was only to give a plaintiff his costs. It was
Yes.
considerably later that there was power to award costs to a defendant, the suggestion being that the defendant ought to be happy just to have defeated the claim.
Lord
Yes, then.
Cook indulging his fantasy in etymology.
Yes, I enjoyed that. Yes.
So those were my submissions on power. If I'm wrong, either on the Superior Court of Record or on there just being a general intrinsic power, or in implied or inherent power in courts and tribunals generally to award costs, what principles should the Commission have applied? It's obviously quite unusual now to have a cost power without any guidance as to how it's to be exercised. But that would be the position that Mr. Justice Chamberlain was in.
Is there not a step before you get to the principles on which it's acted, which is, if there was a power, what is the effect of Section 5.2a on the existence of the power? Has that driven out the power? That's not a point you're making.
It wasn't, but it might be a good
No,
point
no,
which I
no.
ought to make.
I'm not. It was just my understanding that was something from the skeleton.
Could I just briefly look at 5.2a again, just to make sure that I haven't missed something I should have been saying?
I mean, I think you dealt with it probably at the end of your last point, which was saying that there is no power.
Yes. So 5.2a was the power to make rules that may in particular do anything which may be done by rules under Section 106.
That was its first formulation, and
iteration,
then it was
yes.
reformulated later on to reflect the enactment of the 2007 Act.
Yes.
Because, I mean, the one reading of the West Ham Union is, any court of superior record might have that power, but once you've got statute in the field, then you wouldn't.
Yes, I suppose that's part of my submission really, that in an area that's been so regulated by statute, the fact that there is no explicit statutory power ought to be a very strong warning at the very least to the courts not to read in a general implied or intrinsic or inherent power, because it is an area where Parliament has expressly intervened.
Yeah.
But you're not disowning it or disavowing it as a fallback argument, are you?
No, I'm not. No. I don't think there's anything more I want to say other than that, really. So, so no guidance as to how any cost power is to be exercised. And we say, in the absence of rules or guidance, the Commission was entitled to have regard to the approach that's adopted in non-certified appeals, and that was the basis of its sort of alternative, if I am wrong on that.
Yeah.
Costs jurisdiction ought to be exercised broadly along the same lines as the first tier and upper tribunals, dealing with precisely these proceedings, an appeal against a decision to deprive somebody of British citizenship.
And that might be supported by Mr Southey's Article 14 argument.
Yes, indeed.
Because that's the comparator he's chosen.
Yes, precisely. And indeed, one could see that if somehow he was right and Article 14 does apply, but SIAC nonetheless should be adopting a costs follow the event but only in favour of appellants, then appellants in the first tier tribunal might have their own Article 14 argument, saying, well, we're non-certified, that's another status, and we're being treated less favourably than SIAC appellants. So round it goes. Or alternatively, if on the basis of the reasoning in Taylor and Lawrence, which talks about a power in exceptional circumstances to avoid injustice, Mr Justice Chamberlain plainly didn't consider it necessary to avoid injustice on the facts of this case, and the appellant hasn't demonstrated anything exceptional about his circumstances. And we say, we hope, that the appellant's argument Mr Justice Chamberlain erred in failing to hold the Secretary of State's conduct as unreasonable is obviously hopeless. It was an appeal that took days, where the Commission heard detailed argument and evidence, and he didn't simply say it wasn't abusive. We go back to the determination, which I've kept open. What he says at 16, having said 15, it makes it strictly unnecessary to consider whether, if there had been such a power, it would have been appropriate to exercise it. That's a difficult question to answer, because in most cases where a jurisdiction toward costs is conferred, the basis on which the jurisdiction should be exercised is set out in rules. Here, because it's been assumed correctly, in my view, that there is no such jurisdiction, there are no such rules. So there's no guidance as to whether costs are generally to be awarded to the winning party, or only where one party has behaved unreasonably. Although the appeal was successful, I would not regard the Secretary of State's conduct of this appeal as unreasonable. Not just not abusive, but not unreasonable. Sorry, it wouldn't regard it as unreasonable. The Commission rejected the submission that the attempt to relitigate issues of Bangladesh law determined in previous cases amounted to an abuse of the process of the court. Advancing a case based on expert evidence which is ultimately not accepted is not in itself unreasonable. The case was argued properly and proportionately by the Secretary of State. The fact the appellant's arguments prevailed doesn't undermine that conclusion.
So he expressly deals with unreasonableness,
Yes.
in addition to abuse of process.
Yes, precisely.
Yeah. Okay.
And where there is ex hypothesi a very broad discretion, this court will obviously, I don't even need to say it, be very slow to hold that the judge did not exercise that discretion judicially, or that this discretion should be disturbed. We've cited in our Scotus an argument that the well-known cases about the advantages to the judge who dealt with the proceedings in making decisions on costs, who's seen how the proceedings have been conducted and heard that argument.
Well, Mr. Southey accepts those authorities, but says in the particular facts of this case, the Secretary of State went for 6 experts, which is unusual behaviour and unreasonable. What do you say about that?
The Secretary of State didn't go for 6 experts in this case. One needs to read the whole judgment. Issues about Bangladeshi nationality law had previously been litigated in other cases. In some, there was more overlap than there was in others, and it's fair to say I think, without fear of contradiction, that the Commission did not find all of the experts, when they came to give their evidence, to be enormously helpful. So the Secretary of State thought she had identified an expert who was more knowledgeable and more authoritative and would be better able to assist the Commission. And the Commission found it wasn't abusive to proceed on that basis. It's also fair to say that the Commission identified the Dever-Seelan point about the extent to which previous determinations should be a starting point for a later determination as a novel one in this jurisdiction. And so, in short, the reasons summarised there, the Secretary of State has found not to have acted unreasonably.
Thank you.
Can I just briefly turn around again? I don't think you want me to address Article 14 again, so I think those are our
Not
submissions.
only we don't want you, you can't, because it's not an issue.
So unless the court had any questions that I could assist with any further, I think those are really the points we wanted to make.
Not as far as I'm concerned. Oh, I think, my lord and my lady. Thank you very much, Monsieur Venet.
Thank you very much, my lord and my lady.
Yes, Mr. Southey.
Thank you, my lord. If I may, I'd just like to briefly address my learned friend's submissions, broadly in the order in which she made them. Starting point, the first issue that my learned friend raised was whether our case was that all courts effectively have a power to award costs, or whether it's an inherent part of the Superior Court of Record. Our position, quite simply, is one doesn't need to determine that issue. The Superior Court of Record status is the starting point for the reasons I gave, because it requires a different approach. But ultimately the question has to be, because there is a relationship between inherent powers and statutory framework, what the situation is in this case, given both the inherent, what we say are the inherent powers, and the statutory framework. The next point my learned friend took you to was aid and shipping, and the references in aid and shipping, which I think were in the passage I drew attention to this morning, that indicate essentially that Section 51 confers powers on the court. The issue, of course, in aid and shipping was not what the position would have been had there been no statutory power. All the point I was making about aid and shipping, which is why we would submit aid and shipping, supports our submission, is that it makes it clear that ultimately Section 51 is intended to ensure that the courts have a broad discretion that can then be constrained, governed by procedure rules. So there is a purpose on our analysis to Section 51. Section 51 is not meaningless without, if we're right. What it does is make it clear that the powers of the court are broad, but can be constrained by rules. So it sets, if you like, the playing field for a rules committee. And that reflects the language in our submission of Section 51. Section 51, risk of repeating myself, it is an odd provision in the sense it doesn't say the High Court has a power to award cost. What it says, effectively, is cost is discretionary, subject to the rules. The history, and I apologise, I think I was speaking on my feet about the statutes, and I certainly accept, and the Yale article, which we hadn't been able to locate, is clear about this. That I certainly accept that the origin goes back before 1951, and goes back in some cases a very long way, the statutory origin of the power to award costs. But the key point is that, which is consistent in our submission with, for example, the Dockery article, is that it recognises that there has always been a power in the context of equity to award costs. That's at 854.
So what's equity got to do with it?
Well, in the sense, the reason it
But the history we were showing was that the cost powers have been conferred by statute almost from time immemorial.
Well, what it actually indicates,
except in the context of equity, which are different.
well, but what that demonstrates in one sense is that and it goes back to the point about the West Ham Union case in some sense, because the West Ham Union in one sense is the might be said to be the culmination of that twin track approach. Is that you've had courts which have been regulated by statute, and obviously then the statute steps in. You've had courts, the courts of equity, which haven't been regulated, which have developed as part of their inherent powers the power to award costs, which is consistent with the Dockery article, it's consistent with West Ham Union, and so you've. And indeed, that in one sense, the article seems to make the point that that's the origin of the loser pays principle, basically, or the winner recovers their cost principle. Is equity effectively? Is those principles that were developed by the courts of equity? So, what that suggests in my submission is that there has always been. I mean, one of the points my learned friend made against me, and I'll deal with this now. I was going to deal with this later on, was to say, well, look, there's no case law which demonstrates effectively the approach that the courts should adopt in this sort of situation, and that's right, but that's partly in one sense because it's a relatively unusual situation that we're in. We're in a situation where the legislation, we would say, is silent, and that's where, if you like, the approach that's been adopted by courts which have been without expressed powers becomes important. I mean, Osman, again, is consistent with that, because although I completely accept the point that my learned friend made, which is that ultimately the court felt it didn't need to determine whether the earlier judgments were correctly decided. Ultimately, what that it proceeds on, because that in part was the argument, is, and it may be reflective of the argument, but it's a recognition in our submission that courts, again, in the context of habeas, and that may be a relatively narrow jurisdiction, but it may be one of some significance because, again, it appears that there was no statutory basis, that courts have, in circumstances where there isn't a statutory provision, filled in the gap, so as to speak. Now, West Ham, my learned friend, explains primarily on the basis that the House of Lords may be different. But in our submission, it's very difficult to see why the House of Lords should be different if ultimately this is about inherent powers. All the cases that we've been to about inherent powers, the two academic articles we've been to about inherent powers, focus on essentially what is necessary, paraphrasing just for the sake of not going into too much detail at this stage about it because you've heard all of that, but that what is necessary to do justice, essentially. They focus on that sort of issue. And if cost can potentially be necessary to do justice at House of Lords level, it's difficult to see why they can't potentially be necessary at other levels if the issue isn't expressly dealt with by statute. And remember, that approach essentially appears to still be the case in relation to the Supreme Court. We've drawn attention to the statutory framework for the Supreme Court, and the Supreme Court, on the face of it, is in its primary legislation is simply a superior course of record. Now, except there are rules made in relation to the Supreme Court, but the primary legislation is simply the Supreme Court is a superior court of record. My learned friend then turned to Carl and argued, which is not in dispute to be clear, that effectively a superior court of record can't do everything. We don't disagree, but that's why we, to some extent, have focused on what's inherent, because our position is, you look at what's in the inherent powers of the court are, and if this is a superior court of record, that's where the presumption kicks in. Now, my learned friend refers to a passage in CART that indicated SIAC has a very limited jurisdiction. That, in our submission, is a reference to the fact that, of course, there are only a small number of cases that potentially generate appeals to SIAC, but it's not dealing with the extent of the procedural powers then open to SIAC. It's not saying, for example, that the SIAC rules are so clearly a comprehensive code that there are no other procedural powers available. And in our submission, at the risk of repeating myself, one of the critical issues is in our submission whether or not these powers have been excluded, and that to some extent must turn on an area where there clearly is disagreement between the parties. That is whether or not costs are procedural. In terms of whether the costs are procedural, in our submission there are a number of matters that suggest they are procedural. Firstly, the apparent existence, see West Ham Union, see the Dockery article, of an inherent power. Secondly, if you look at the Jacob article, which my learned friend took you to on page 1434, the first, sorry, I think it's tab 59. The first point was she drew attention to was that Jacob highlights or suggests that one principle is that inherent jurisdiction is exercisable as part of the administration of justice. Well, in our submission, that's precisely why costs exist. It's because part of the administration of justice is determining who should bear the burden of bringing the matter before the court. It potentially controls access to the courts. It potentially also controls how litigation is conducted. That's why, for example, you get cost orders at interim stages in light of, for example, failed applications. It determines process. The second point my learned friend relies upon is what Jacob says, which is the distinctive feature of inherent jurisdiction is it's exercisable by summary process, i.e. without a plenary trial being conducted. Again, in our submission, that's precisely the position with costs. Costs can be awarded before the trial, can be awarded without any trial, and isn't necessarily determined directly by the outcome of the trial. It can reflect the conduct of parties. My learned friend then took you to another passage within the Jacob article and indicates that which says that the inherent jurisdiction is to prevent oppression or injustice. I'd emphasise the word injustice, and to enable the courts to control and regulate their own proceedings. But that's exactly what costs do. Again, they, for example, prevent abusive behaviour. Remember, my learned friend's argument in terms of power has to be that, for example, there's no power to award costs, even if the Secretary of State behaves totally unreasonably, whether or not that's this case. My learned friend then turned to the Dockery article. It's worth noting, I hadn't located footnote 38, but of course the Pringle article, Pringle judgment cited isn't House of Lords, consistent with our case, which is that there's no reason why any inherent power is restricted to the House of Lords. But more importantly, in one sense, the principle I think the learned friend drew from Dockery is Inherent powers are ones that are needed to manage the work of the court in an appropriate fashion. And that's, again, what costs do. They manage the work of the court in an appropriate fashion by, for example, penalising abusive litigation. My learned friend then took you to Taylor and Lawrence and argued essentially, in part, that one of the functions of, argued it seemed to be the main function of inherent powers was to control abuse. In our submission, there are clear statements of principle that indicate that the inherent powers are not controlled in that way, or not limited in that way. But even if they were, going back to the point I made before, which is that, of course, the cost jurisdiction can be important to control abuse. In any event, in our submission, the critical points about the key point about costs in our submission is that if one goes, for example, to Wicks at page 474, I'm sorry, I haven't got tab numbers, but that's where the Court of Appeals cite Lord Denning. He talks about procedural powers to enable one to do what is fair. Taylor and Lawrence, page 497, talks about a general power to decide procedure. Jacob, 1461, talks about a reserved power to do what's just. In our submission, that demonstrates that my learned friend is wrong to pick up the point raised by my Lord, the Vice President, which is effectively picking up from Justice Chamberlain, the idea that costs need to be necessary. In our submission, necessary may raise a question as to what necessary means in this context, but my own friend picked up on it to suggest it was a very high threshold. It meant effectively that costs were necessary if it was going to be possible to, we need to demonstrate essentially costs needed to be required if there was going to be a determination at all. In our submission, that is too high a threshold. What the case law that I've just taken you to, what the Jacob article demonstrates is that inherent powers are there to enable justice to be done. That should be, that is the key question. At about that point, my learned friend also took you to the W and a public authority, the IPT tribunal. In our submission, the circumstances in which a power not to, or there's no power to award costs essentially, are actually relatively limited. And if one thinks about the IPT itself, the IPT, of course, is in part because of its very closed nature, and because effectively it's a situation where an individual is bringing a complaint in circumstances where they don't even know quite often whether or not they've been affected by the conduct of the state. It is not a truly adversarial process. The first tier tribunal, health and education tribunal that I have a certain amount of experience of, is unusual in the sense that it is the key control over whether someone who may lack capacity is, well, not just may lack capacity, but certainly is mentally or may be mentally disordered more generally, has been unlawfully detained. And so again, it's not necessarily, in a classic sense, an adversarial tribunal. And so in our submission, it is still the case that SIAC, in circumstances where there is a clear challenge by the individual to an action of the state which is clearly identified, it's quite unusual for there not to be any power to award costs. It's very difficult to know what you don't know, but and that's, in one sense, where the comparison with the FTT comes into play. if the starting point is that there is would be a power to award costs, absence anything in the current statutory regime, what is the effect of section 5.2a? My learned friend, fairly lightly in my submission, suggested that any power was driven out by section 5.2a, but that is simply the power to make rules regarding regulation. That's why, in opening, I've turned to what the nature of the tribunal procedure rules is. It is a power to regulate, a power conferred by primary legislation or by inherent powers. It is not the establishment, effectively, of a power. So it cannot be read in my submission as being a provision which essentially says, without rules, you cannot have costs. In terms of the approach that should be adopted, in my submission, if it's accepted that for whatever reason no rules have been issued, then the FTT has to, not the FTT, the SIAC has to determine its own practice in this area. And there is no basis in our submission in circumstances where the actual practice of the litigation is significantly different to the FTT to adopt the narrow approach adopted in the FTT. And with respect to Mr. Justice Chamberlain, in terms of his reasoning, it is in our submission pretty unclear why the FTT approach is being adopted. Finally, in terms of the unreasonable misconduct, ultimately this court is going to read paragraph 16 and make of it what it will in terms of the extent to which there was separate consideration to unreasonableness and abuse. All I would say is that my learned friend says, perhaps not unrealistically, that the previous experts regarding Bangladeshi nationality law were not as unhelpful as they might have been. So the Secretary of State essentially went to find another, or did find another. The problem with that, ultimately, is as SIAC itself noted, you cannot carry on doing that indefinitely, because otherwise individuals continue to be put to great expense. And ultimately, the consequence of that was a lengthy hearing, 5-day hearing, I think it was, a week-long hearing roughly, to further review a matter that had been litigated repeatedly.
But it presumably hasn't been litigated again.
Sorry?
This issue presumably hasn't been litigated again.
No. And I think, in fairness, and just to be clear, because Milady will know this as well because of other litigation. Of course, when this was determined, and I accept this, E3 and N3 was pending, and Milady knows that the Secretary of State withdrew the E3 N3 decision at that point in light of this.
So, I mean, that's really all I was getting at. If there did come a point where the Secretary of State folded his or her tent and said, okay, I accept what the position is.
Yes.
Okay.
I think that, can we just check? Sorry, the one point my juniors asked me to just remind you of is that, of course, the 2007 Act, Section 22, consistent with what we say about inherent powers, makes it clear that costs are essentially procedural. Thank you.
Right. Thank you very, very much indeed. We will be reserving our decision. Judgments will be circulated in draft in the usual way. I don't need to remind you of the very strict rules governing the purposes for which and therefore to whom they may be further circulated prior to hand down. The purpose, of course, is partly to draw our attention to any typographical or other minor errors, and partly also to enable the parties to agree, if possible, any consequential issues, and if they can't, to prepare a brief written submission so that we can decide those issues at the time of hand down. Thank you very much.